Good evening, ladies and gentlemen, and once again you're listening to The American Dissident. I had a few difficulties here with dropped internet connections, but everything, I hope, from reading what's going on seems to work right. But anyway, some of you might or may have not known that I haven't been on the air for a while because there was some tumultuous times in my personal life, a messy divorce and a custody battle with my sons. And the purpose of this show and why I'm back on the air is to educate the American people about what a constitutional government is and the ever-increasing assault and loss of our freedoms all across our great land. And we are in what quote-unquote is the presidential election season, and most likely that Hillary Clinton is going to be the Democratic nominee, and there's some 17 men and women running on the Republican side for president, and we will go through what is constitutional and what is not constitutional to be eligible for the office of President of the United States. I'm on Facebook, as some of you may or may not know, and I've lost some quote-unquote friends debating them as to why Ted Cruz in particular is not eligible to be President of the United States. And I am going to go through some of the references that they cite as to why he is, and I'm going to prove to you in the founder's own words where they got the meaning of the term natural born citizen, and why Ted Cruz and Marco Rubio and Bobby Jindal and Hillary Clinton and Carly Fiorina are not eligible to be President of the United States. And I do really not care whether or not you support your guy and like the message. They are not eligible to be president, and the quality of this country and its government is only as good as the quality of the people in this country electing it. And we will go through some of the sources that people in the debates have gotten into me with when they cite why they believe that Ted Cruz is eligible to be president. And we are going to go to one of the websites that a lot of these people cite. It's the Harvard Law Review. And we will get into this, and you got to bear with me because I haven't done this for a while. So we're going to go and see what we can do here so I can read. And something seems to not be wanting to work, but I'm going to try to get it to work. Why my Procaster doesn't seem to want to work. And here we go. We're on harvardlawreview.org, and this is one of the websites that people in support of Cruz cite as to why that he's qualified to be president. And I'm going to read this to you verbatim from the Harvard Law Review. It's the harvardlawreview.org, and we will start. Let's see what we've got here. We have both had the privilege of heading the office of the Solicitor General during different administrations. We may have different ideas about the ideal candidate in the next presidential election, but we agree on one important principle. Voters should be able to choose from all constitutionally eligible candidates, free from spurious argument that a U.S. citizen at birth is somehow not constitutionally eligible to serve as president simply because he was delivered at a hospital abroad. The Constitution directly addresses the minimum qualifications necessary to serve as president. In addition to requiring 35 years of age and 14 years of residency, the Constitution limits the presidency to a natural-born citizen. And the Harvard Law Review, in saying that they are right. The Constitution does limit the office of the presidency to a natural-born citizen. All the sources routinely used to interpret the Constitution confirm that the phrase natural-born citizen has a specific meaning, namely someone who was a U.S. citizen at birth with no need to go through a naturalization proceeding at some later time. Well, here, ladies and gentlemen, the qualifications for president do not mention anything about a naturalization process. All they say in the requirement to be eligible to the office of the presidency is you be a natural-born citizen. And Congress has made equally clear from the time of the framing of the Constitution to the current day that subject to certain residency requirements on the parents, someone born to a U.S. citizen parent generally becomes a U.S. citizen without regard to whether the birthplace takes place in Canada, the Canal Zone, or the continental United States. And I'm going to prove to you, ladies and gentlemen, that is a lie. That the Harvard Law Review is lying when they make that statement. While some constitutional issues are truly difficult, with framing area sources either non-existent or contradictory, here the relevant materials clearly indicate that a natural-born citizen means a citizen from birth with no need to go through the naturalization proceedings. And they are right in one part of the statement and they lie in another part. There is plenty of sources that exist on the internet and written down in books that clearly indicate what the framers and the founders meant when they coined the term natural-born citizen. And I have them here on the internet, and I'm going to read those to you. The Supreme Court has long recognized that two particularly useful sources in understanding constitutional terms are British common law and enactments of the First Congress. And that there again, ladies and gentlemen, is a lie. The Founding Fathers did not use British common law to frame the Constitution. They abhorred British common law. They left England because of an oppressive government. They hated King George, they hated the monarchy, and they hated everything that had to do with England. They used French common law in order to frame the Constitution. So once again, the Harvard Law Review, they're lying to you. Both confirm that the original meaning of the phrase natural-born citizen includes persons born abroad who are citizens from birth based on the citizenship of a parent, and that is a lie once again. As to the British practice, laws in force in the 1700s recognized that children born outside of the British Empire to subjects of the Crown were subjects themselves and explicitly used natural-born to encompass such children. These statutes provided that children born abroad to subjects of the British Empire were natural-born subjects to all intents, constructions, and purposes whatsoever. The framers, of course, would have been intimately familiar with these statutes and the way they used terms like natural-born, since the statutes were binding law in the colonies before the Revolutionary War. There again, there's the key. The statutes were binding in law in the colonies before the Civil War, but they were not binding after the Revolutionary War. But they weren't binding after the Revolutionary War, and the United States Constitution was ratified in 1789, some 13 years after the Revolutionary War began. They were also well documented in Blackstone's commentaries, a text widely circulated and read by the framers and routinely invoked in interpreting the Constitution. No doubt informed by this long-standing tradition, just 3 years after the drafting of the Constitution, the first Congress established that children born abroad to U.S. citizens were U.S. citizens at birth. But there again, ladies and gentlemen, they're blurring the distinction. The Constitution does not state anything about you being a U.S. citizen to be qualified for the office of the presidency. It states that you must be a natural-born citizen, and explicitly recognize that such children were natural-born citizens. The Naturalization Act of 1790, and here again they're trying to blur terms. There are three distinct legal definitions of citizenship in this country. One, you are a U.S. citizen. Two, you are a natural-born citizen. Or three, you are a naturalized citizen. Provided that children of citizens of the United States, that may be born beyond sea or out of the limits of the United States shall be considered as natural-born citizens, provided that the right of citizenship shall not descend to persons whose fathers have never been resident in the United States. The actions and understandings of the First Congress are particularly persuasive because so many of the framers of the Constitution were also members of the First Congress. That is particularly true in this instance, as 8 of the 11 members of the committee that proposed the natural-born eligibility requirement to the convention served in the First Congress, and none objected to a definition of natural-born citizen. That included persons born abroad to citizen parents. The proviso in the Naturalization Act of 1790 underscores that while the concept of natural-born citizen has remained constant and plainly includes someone who is a citizen from birth by descent without the need to undergo naturalization proceedings, the details of which individuals born abroad to a citizen parent qualify as citizens from birth have changed. And they have not changed, ladies and gentlemen. These laws have not changed, and the Constitution has not changed. Where is their political reference or their law or their statute to cite that the Constitution has changed? It hasn't. It has not changed. And there, once again, in this article, they are lying to you. The pre-revolution British statutes sometimes focus on paternity such that only children of citizen fathers were granted citizenship at birth. The Naturalization Act of 1790 expanded the class of citizens at birth to include children born abroad of citizen mothers as long as the father had at least been resident in the United States at some point. But Congress eliminated that differential treatment of citizen mothers and fathers before any of the potential candidates in the current presidential election were born. Thus, in the relevant time period and subject to certain residency requirements, children born abroad of a citizen parent were citizens from the moment of birth and thus are natural-born citizens. And that's a lie. They are not natural-born citizens. The original meaning of natural-born citizens also comports with what we know of the framers' purpose in including this language in the Constitution. The phrase first appeared in the draft Constitution shortly after George Washington received a letter from John Jay, the future first Chief of Justice of the United States, suggesting whether it would be not wise and seasonable to provide a strong check to the admission of foreigners into the administration of our national government, and to declare expressly that the Commander-in-Chief of the American Army shall not be given to nor devolve on any but a natural-born citizen. As recounted by Justice Joseph Story in his famous commentaries on the Constitution, the purpose of the natural-born citizen clause was thus to cut off all chances for ambitious foreigners who might otherwise be intriguing for the office and interpose a barrier against the corrupt interferences of foreign governments in executive elections. The framers did not fear such machinations from those who were U.S. citizens from birth just because of the happenstance of a foreign birthplace. Indeed, John Jay's own children were born abroad while he served on diplomatic assignments. It would be absurd to conclude that Jay proposed to exclude his own children as foreigners of dubious loyalty from presidential eligibility. Well, he did, ladies and gentlemen, because he and the rest of the founders did not want foreigners to be president. And I'm going to show you in subsequent articles that can be found on the internet what a true natural-born person is. While the field of candidates for the next presidential election is still taking shape, at least one potential candidate, Senator Ted Cruz, was born in a Canadian hospital to a U.S. citizen mother. Despite the happenstance of a birth across the border, there is no question that Senator Cruz has been a citizen. Now you see here, ladies and gentlemen, they did not say a natural-born citizen. It says Senator Cruz has been a citizen from birth. That is not what the Constitution says. It says a natural-born citizen. And then they go on to say, and is thus a natural-born citizen, but that is wrong within the meaning of the Constitution. Indeed, because his father had also been resident in the United States, Senator Cruz would have been a natural-born citizen even under the Naturalization Act of 1790. Similarly, in 2008, one of the two major party candidates for president, Senator John McCain, was born outside the United States on a U.S. military base in the Panama Canal Zone to a U.S. citizen parent. And, ladies and gentlemen, John McCain was born, as the article correctly states, he was born in the Panama Canal Zone, but he was naturalized by an act of Congress, and that is not the same as a natural-born citizen. Despite a few spurious suggestions to the contrary, there is no serious question that Senator McCain was fully eligible to serve as president. wholly apart from any murky debate about the precise sovereign status of the Panama Canal Zone at the time of Senator McCain's birth. There is no murky debate. The law is the law and the Constitution is the Constitution. They're trying to dumbfound you with spurious words and spurious phrases. The U.S. Senate unanimously agreed that Senator McCain was eligible for the presidency. Well, the Constitution didn't unanimously agree that Senator McCain was eligible for the presidency, and the Senate nor the U.S. House of Representatives has the power to make anybody anything. Resolving that any interpretation of the natural-born citizenship clause as limited to those born within the United States was inconsistent with the purpose and intent of the natural-born citizen clause of the Constitution of the United States, as evidenced by the first Congress's own statute defining the term natural-born citizen. And for the same reasons, both Senator Barry Goldwater and Governor George Romney were eligible to serve as president, although neither was born within a state. Senator Goldwater was born in Arizona before its statehood and was the Republican Party's presidential nominee in 1964, and Governor Romney was born in Mexico to U.S. citizen parents and unsuccessfully pursued the Republican nomination for president in 1968. There are plenty of serious issues to debate in the upcoming presidential election cycle. The less time spent dealing with specious objections to calendar eligibility, the better. Why? The president, before he takes office, must take an oath to preserve, protect, and defend the Constitution. And it's not a specious objection to candidate eligibility. Either you're eligible for the office or you're not. Fortunately, the Constitution is refreshingly clear on these eligibility issues. And of course it is, but the Harvard Law Review is not refreshingly clear on what a natural-born citizen is. And once again, I'm going to prove that to you, ladies and gentlemen, that these people are liars. 34.5 is not enough, and for better or worse, a naturalized citizen cannot serve. But as Congress has recognized since the founding, a person born abroad to a U.S. citizen parent is generally a U.S. citizen from birth with no need for naturalization, and the phrase natural-born citizen in the Constitution encompasses all such citizens from birth. It does not, ladies and gentlemen. It does not. They're lying once again. Thus, an individual born to a U.S. citizen parent, whether in California or Canada or the Canal Zone, is a U.S. citizen from birth and is fully eligible to serve as president if the people so choose. There again, they're blurring the distinction, ladies and gentlemen. The Constitution does not say a U.S. citizen. It says a natural-born citizen. And they are trying to blur the distinctions between two legal, distinct terms. And what references do these people cite? We have at the end of this article Paul and Patricia Saunders, Professor of Law, Georgetown University, Distinguished Lecturer in Law, Georgetown University, Partner Bancroft PLLC. Where is the reference material, ladies and gentlemen, to source whether or not these people are telling the truth? They have not cited anything except in these footnotes where you can go see. And if you want to source some of these things, you're free to do so. And we're going to close out this one, and we're going to go to another article that the Cruz supporters and so-called patriots in this country probably use to support their contention that Ted Cruz is eligible to be president. And I'm going to go back up here to the Procaster control bar, and we are going to go to the next article that some of the Cruz supporters and probably the Jindal supporters and probably the Carly Fiorina supporters and everybody else who supports their guy will probably use in a debate against me as to why Ted Cruz is constitutionally eligible to be president. This is from townhall.com, www.townhall.com, ladies and gentlemen. And what happened to my article? But we will go find it here momentarily. do not know what happened to my article here, but we will try to go back. Here we go. And we will look at this. This comes from March 23rd, 2015. Again, it's www.townhall.com. And the headline leading into the article, yes, Ted Cruz is constitutionally eligible to be president. And here we have a nice picture of Ted Cruz speaking and waving to adoring crowds. And we will read this article. I'm just trying to be fair to the people that support Ted Cruz and these other people. And I'm trying to present both sides of the story, since I've lost friends on Facebook. I've been kicked out of groups because of my contention that he's not eligible to be president. And I'm going to present my side of the issue, and then I'm going to let you make up your own minds. In light of Ted Cruz's presidential announcement this morning, that quote-unquote issue of his constitutional eligibility has again cropped up in some circles. Allow me therefore to re-up this post I wrote almost exactly 2 years ago. Hey, at least they're bipartisan. For the uninitiated, the Texas senator and conservative stalwart was born in Calgary, Canada. And that, ladies and gentlemen, there is no question where Ted Cruz was born. He was born in Calgary, Canada, and he can't hide that fact, and he freely admits that he was born in Canada, prompting some to insist that he is not a natural-born citizen and is therefore ineligible for the presidency. But there are only two types of citizens under the law, and that is a lie. There are three types of citizens under the law. There is a U.S. citizen, there is a natural-born citizen, and there is a naturalized citizen, and in the subsequent website that I am going to give you, you are going to see that. Natural-born Americans from birth and naturalized Americans who undergo the legal process of becoming a U.S. citizen. Cruz never experienced the latter proceedings because he didn't need to. His mother was born and raised in Delaware, rendering Cruz an American citizen from the moment of his birth. Now there again, I'm not questioning that, because yes, he is an American citizen at birth. But he is not a natural-born citizen. There again, in this article, they are trying to blur the distinctions. Meanwhile, Cruz has even indicated if he has any designs to pursue a White House run. He's got his hands full in the United States Senate. National Review has more on this preposterous debate. Legal scholars are firm about Cruz's eligibility. Of course he's eligible, Harvard Law professor Alan Dershowitz tells National Review Online. He's a natural-born, not a naturalized citizen. Eugene Volko, a professor of the UCLA School of Law and longtime friend of Cruz, agrees, saying the senator was a citizen at birth and thus a natural-born citizen, as opposed to a naturalized citizen, which I understand to mean someone who becomes a citizen after birth. Federal law extends citizenship beyond those granted it by the 14th Amendment. It confers the privilege on those born outside the United States whose parents are both citizens, provided one of them has been physically present in the United States for any period of time, as well as those born outside of the United States to at least one citizen parent who after the age of 14 has resided in the United States for at least 5 years. Cruz's mother, who was born and raised in Delaware, meets the latter requirement. So Cruz himself is undoubtedly an American citizen. Well, of course, ladies and gentlemen, he is undoubtedly an American citizen. He is a U.S. citizen. But is he a natural-born citizen? And there lies the great conundrum, ladies and gentlemen. And I am going to prove to you through other websites that he is not. I'm going to present both sides of the issue, and I'm going to present them so you can clearly see through the lies in these two articles. No court has ruled what makes a natural-born citizen, and that's not entirely the case either, ladies and gentlemen, because the court has briefly touched upon what a natural-born citizen is. And I believe in their two brief statements that they made it abundantly clear what a natural-born citizen is. Again, no court has ruled what makes a natural-born citizen, but there appears to be a consensus that the term refers to those who gain American citizenship by birth rather than by naturalization, again including Texas Junior Senator Cruz, a constitutional lawyer, ladies and gentlemen, and I have a friend on Facebook who was a former lawyer, and she agrees with me. And she made the statement to me that Cruz is a lawyer himself, and he knows that he's not eligible, and her statement, to paraphrase, is that he is gaming the system. And he is gaming the system, ladies and gentlemen, just as Barack Obama gamed the system. He's counting on your ignorance to try to clear a path to the White House, which he knows he's not eligible to be. He's doing this country a disservice. He's doing the American people a disservice by running for president, and he is a liar. His press secretary, Catherine Frazier, tells National Review Online that while a 2016 run is far from his mind right now, he's fully focused on his role representing Texas and the Texans in the U.S. Senate. There should be no confusion about his presidential eligibility. I'm not confused, but here's this statement. He is a U.S. citizen by birth, having been born in Calgary to an American-born mother, Frazier says. Well, of course he's a U.S. citizen, but the Constitution does not say, once again, the Constitution does not say a U.S. citizen. It says a natural-born citizen. If you don't believe it, go get a copy of the Constitution and read it. Read the presidential qualification. It says nothing about a United States citizen. Nothing. Nothing whatsoever. The Cruz questioners adhere to a slightly different strain of bitheism than Obama's critics, who have questioned the authenticity of his Hawaiian birth. Whereas the Obama doubters allege a full-blown conspiracy to hide the president's true origins, the Cruz crew is quarreling over an interpretation of the law. Senator Marco Rubio has also drawn Bertha's attention, but for a third reason. This group concedes that Rubio was born on U.S. soil in Miami to Cuban parents, but asserts that anchor babies shouldn't be considered natural-born citizens under the 14th Amendment. This is also a legally dubious interpretation, to put it charitably. To recap, the Berthas have latched on to three separate forms of eligibility skepticism. Well, I thought in the lead-up to this article that there's only two forms of citizenship. Now they're going in this article and saying that there's three. A politician is lying about being born in America. 2, a politician was born in another country, which precludes him from claiming natural-born status. And 3, a politician was born in America, but his parents weren't citizens at the time. The Congressional Research Service offers a succinct explanation of how the natural-born clause should be applied. The weight of legal and historical authority indicates that the term natural-born citizen would mean a person who is entitled to U.S. citizenship by birth or at birth. But there again, ladies and gentlemen, they are trying to confuse you and confound you. The Constitution says nothing about U.S. citizenship. Nothing. Again, either by being born in the United States and under its jurisdiction, even those born to alien parents, by being born abroad to U.S. citizen parents, or by being born in other situations meeting legal requirements for U.S. citizenship at birth. Such term, however, would not include a person who was not a U.S. citizen by birth or at birth, and who was thus born to an alien required to go through the legal process of naturalization to become a U.S. citizen. Byron York delved deeper into the eligibility laws last year. First, there are people born inside the United States. No question about that. Their citizenship is established by the 14th Amendment. Then there are the people who are born outside the United States to parents who are both American citizens, provided one of them has lived in the U.S. for any period of time. And then there are the people who are born outside the United States to one parent who is a U.S. citizen and the other who is an alien, provided the citizen parent lived in the United States or its possessions for at least 5 years, at least 2 of them after the age 14. The law is really quite lenient, and maybe the law is quite lenient, ladies and gentlemen, but the Constitution is the supreme law of the land, and it is not lenient. If a child were born today in, say, Kenya to a Kenyan father and an American citizen mother who had lived in the United States for at least 5 years, at least 2 of them over the age of 14, that child would be a citizen of the United States by birth and be eligible for the White House. What about a child born in the United States to non-citizen parents? I am not aware of anyone who has contended that someone could be born in the United States and be a citizen by virtue of the 14th Amendment and nevertheless still not be a natural-born American citizen, says Washington lawyer Matthew McGill, who worked with Olson on the McCain case and did extensive research into the law and history of citizenship. Well, did he? I don't think that he did, ladies and gentlemen. If he is born in the United States, his parentage is not of consequence. Oh, I'm going to prove to you, ladies and gentlemen, that it is. I'm going to prove to you, ladies and gentlemen, that parentage and where you are born is the strictest test to become President of the United States. Two other prominent Republicans have attracted birther scrutiny. Louisiana Governor Bobby Jindal, who was born in Baton Rouge to Indian immigrants, and Mitt Romney, a native of Michigan. Romney's father, who ran for president in 1968, was born to American parents in Mexico. I'll leave you with a tip of the hat to the Huffington Post for coining the term equal opportunity annoyers to describe the marginal birther movement. Perfect. And here, ladies and gentlemen, where is the source material that they cite? Here's a man who commented on this post, and he is correct. Once again, an article full of misinformation about the term natural-born citizen. There are not two types of citizens, there are three. Citizens, natural-born citizens, and naturalized citizens. That one is a citizen does not make one a natural-born citizen. And Mr. Don Frederick is correct. And I'll keep going down here. But they cite no reference material, ladies and gentlemen, for you to look at. They cite no history. All we have is a bunch of people debating who is and who isn't. So you see, ladies and gentlemen, you got to watch before you read. These people have cited no source material for you to reference. They have created an article, and they want you to believe it. They want you to believe it. Now I'm going to go back to the camera, and I am going to say that unequivocally, once again, Ted Cruz is not eligible to be President of the United States. And I'm going to go to my material, the correct material, and I'm going to prove to you that these two articles and you Cruz supporters are wrong. And we are going to go, ladies and gentlemen, to thefreerepublic.com. And this, ladies and gentlemen, is a wonderful website. It is full of source material for you to search. In order to be free, you have to search and research. What is it that it said in the Bible? Seek ye the truth, and the truth shall set ye free. That is what we're going to do here, ladies and gentlemen. And again, this is www.freerepublic.com. And it has the complete history of U.S. citizenship, what a naturalized citizen is, and what a natural-born citizen is. And I'm going to read, this is a very long article, this is packed full of information, and I'm going to read this to you. And you are going to understand what a natural-born citizen means. And if you're still not convinced, I'm going to go to another website that has basically the same meanings. And you will find, and in the Harvard Law Review and in that article by Town Hall, they mention none of these things. Because they're counting on you not to look. They're counting on you not to look. They're counting on you to be ignorant. They're counting on your ignorance, is what they're doing. And this was posted on January 31st, 2012. And it is the constitutional meaning of natural-born citizenship. And this man, Sorcery, is a very bright gentleman, because he did it all here for you. The lead up. The Constitution requires that the President of the United States must be a natural-born citizen. Article 2, Section 1, Paragraph 5, quote, No person except a natural-born citizen or a citizen of the United States at the time of the adoption of this Constitution shall be eligible to the office of President. Neither shall any person be eligible to that office who shall not have attained the age of 35 years and been 14 years a resident within the United States. If natural-born citizen is a synonym for citizen, then there is no reason for adding the exception or a citizen of the United States at the time of the adoption of this Constitution. None at all. Being a citizen is not sufficient unless you happen to be alive when the Constitution was adopted. So what then is a natural-born citizen? To answer that question definitively will require a full examination of the concepts and history of citizenship. Types of citizenship: just solely, just sanguineous, natural-born, native-born, naturalized. Just solely is a Latin phrase meaning law of the soil. Just solely citizenship is any citizenship that inheres in a person based on the location of his or her birth. Again, the location of his or her birth. We all know that Ted Cruz was born in Canada. Just sanguineous citizenship is a Latin phrase meaning law of the blood. Just sanguineous citizenship is any citizenship that inheres in a person based on his or her ancestry. Native-born citizenship. A native-born citizen is one of whose citizenship derives from the facts of his birth and who becomes a citizen at the moment of birth. In both U.S. and British law, those born within the sovereign territory of the country or born to parents who are citizens, parents, subject of the country when the person is born, are native citizens, subjects. Native-born persons are said to have birthright citizenship. Note that one can be native-born either by the just solely principle or by the just sanguineous principle. Naturalized citizenship. A naturalized citizen is one whose citizenship is granted as a political act, by law or by the decision or act of a sovereign. Natural-born citizenship. A natural-born citizen is one whose citizenship is not granted by law or by any act of a sovereign. And when he says that, ladies and gentlemen, it means by any act of the king, the queen, the pope, the bishop, or the United States Congress, but inheres naturally in the person from birth according to principles that don't depend on laws or decisions of a sovereign. The rest of this essay will fully justify this definition. The Constitution of the United States did not originally explicitly define who or did not qualify as citizens. It originally had clauses where the general term citizen occurs, and had one clause where the specific term natural-born citizens occurs. But the Constitution does not grant Congress the power to define by law who shall be citizens. Congress shall have power to establish a uniform rule of naturalization, Article 1, Section 8. Why did the Constitution limit the power it granted Congress over matters of citizenship to naturalization? Because citizenship acquired solely by any law passed by Congress cannot logically be anything other than naturalized citizenship, by definition of naturalization. It's logically impossible for any act of Congress to make anyone a citizen by natural law. At most, such a law would be declaratory of natural law, because a citizen by natural law is a citizen no matter what laws Congress may or may not enact. In fact, given the founders' understanding of natural law versus man-made law, it would have been a logical contradiction to grant Congress the power to change or define natural law on any subject, not just regarding citizenship, because natural law, by the late 18th century definition, cannot be made by a legislator or a head of state. That's why Congress was granted no such powers in any domain at all. Such a power could be used, among other things, to change the meaning of words, including those in the Constitution itself. The dangers of that should be obvious. If Congress had the power to make anyone a natural citizen, it would also necessarily have the power to strip citizenship from anyone it chose. The fact that it cannot logically have any such power and is granted no such power by the Constitution is one of the fundamental protections against tyranny. The power to revoke even natural law citizenship by law is the power to commit any act against anyone that the sovereign power of war permits. So why didn't the Constitution define the term natural-born citizen? For the same reason it can only grant Congress the power to define naturalized citizens. For the Constitution to actually define the term natural-born citizen would necessarily mean that the status would be granted by man-made law and not natural law. And the Constitution, ladies and gentlemen, is rooted in natural law. It is not rooted in any man-made law. That's why the Constitution provides no definition, and why it must be a court that decides who is and who is not a natural-born citizen by applying natural law principles, which is exactly how English common law handled questions of natural citizenship. But the ratification of the 14th Amendment introduced into the Constitution a rule of citizenship that declared anyone who A, was born in the United States, and B, who was subject to U.S. jurisdiction at the time of his or her birth to be a citizen. Well, there, ladies and gentlemen, Ted Cruz is not even a 14th Amendment citizen because he was born in Canada. He was not born in a U.S. jurisdiction. He was born in a foreign land. He was born in Canada. Since the 14th Amendment is a man-made law and is not natural law, the 14th Amendment logically cannot make anyone be a natural citizen, nor does it create the logical contradiction of attempting to do so, since it makes no mention of natural citizenship of any kind and does not use the term natural-born citizen. The 14th Amendment created an implicit distinction among 14th Amendment native-born citizens and statutory non-native-born citizens. A statutory native-born citizen is a person who does not qualify for birthright citizenship under the 14th Amendment, but receives U.S. citizenship at birth by laws enacted by Congress. For example, foreign-born children of American parents do not receive citizenship from the 14th Amendment. Such children acquire U.S. citizenship at birth by statute. So those born outside the United States to parents who are U.S. citizens at the time of the person's birth are both native citizens and also naturalized citizens, since their citizenship is A, granted to them by an act of Congress, and B, effective from the instant of their birth based on the fact that the person's parents were U.S. citizens at the moment. Even those born in the United States, if they qualify as a citizen per the 14th Amendment, but do not also qualify as natural-born citizens, without reliance on the 14th Amendment, are naturalized citizens. Why? Because the U.S. Constitution is a law whose formulation and adoption are political acts of man. The Constitution is the supreme law of the land, but it is not natural law. So it does not matter that the law that grants citizens happens to be a clause of the Constitution. The grant of citizenship is nevertheless an act of naturalization, because it's a grant made by law, a political act, not one based on natural law. Those who were not citizens up until the moment of the ratification of the 14th Amendment, but who instantly became citizens upon ratification, cannot possibly have ever been native-born American citizens. They were not citizens from the moment of their birth, and their grant of citizenship was a political act effected by the passage of law and not based upon principles of natural law. The 14th Amendment naturalizes anyone who does not qualify as a natural-born citizen, and that's true by definition of the term naturalization and will be fully and comprehensively shown later. Therefore, to handle all the possible classes of citizenship in the U.S., it is necessary to distinguish between natural law citizens, constitutional citizens, and statutory citizens, and also distinguish between native citizens and non-native citizens. And here they have a nice little chart. Natural law. Native from birth. Native citizen per natural law, natural-born citizen. Non-native post-birth. Non-native citizen per natural law. Those who become citizens of a newly created nation. Constitutional law. Naturalized native citizen per constitutional definition. Naturalized non-native citizen per constitutional definition, and it does not currently exist. Statutory law. Naturalized native citizen per statutory definition. Naturalized non-native citizen per statutory definition. Of course, in other countries, other classes of citizenship may exist, and classes of citizenship that exist in the U.S. may not. For example, some countries don't have constitutions or even legislatures, and others have monarchs who may have the power to grant citizenship, a power which the United States President lacks. We can use the term constitutional natural-born citizen to refer to someone who is a natural-born citizen according to the natural law-based definition intended by those who wrote and ratified the Constitution. The term must be understood in that sense when it appears in the Constitution or in a Constitution-related matter such as a Supreme Court decision. We can use the term statutory natural-born citizen to refer to someone who is deemed a natural-born citizen by federal or state law. These distinctions are not my invention. The U.S. Department of State Foreign Affairs Manual, which there is a link that you can download or look at in page 9, it says, "The fact that someone is a natural-born citizen pursuant to a statute does not necessarily imply that he or she is a citizen for constitutional purposes." If we were to define natural-born citizen to mean anyone who is a citizen at birth, our definition of natural-born citizen would be statutory, because it would depend on the statute of law which defines citizen at birth. Under existing law, all children born outside the United States to parents who are citizens at birth. Therefore, using our hypothetical definition of natural-born citizen as anyone who is a citizen at birth, all those born abroad to U.S. citizen parents would be statutorily defined as a natural-born citizen, because their status as citizens at birth would be granted by statute. So that definition of natural-born citizen would mean that Congress could change the meaning of natural-born citizen by changing the rules of naturalization. It would also mean that Congress, simply by changing the naturalization rules, could also change who was or who was not eligible to be president. And Congress, ladies and gentlemen, has no such authority. That cannot be what the founders intended. Had it been, they would simply have granted Congress the power to dictate who shall or who shall not be a citizen, and who could or could not be president. But they pointedly did not grant Congress any power to determine who would not naturally be citizens, nor who would be eligible to be president. The only power they granted Congress regarding citizenship was to make rules regarding naturalization of citizens, the making of citizens who would not be citizens naturally, and they granted Congress no power to determine presidentiality rules at all. It may be, as this essay so argues, that all natural-born citizens are also native-born citizens, but the reverse cannot be true without only creating logical contradictions, but without granting Congress powers that were clearly intended to be denied to them. The original intent. On 25th July 1787, John Jay wrote a letter to George Washington recommending that the new Constitution should require that the President be a natural-born citizen. The stated purpose of this requirement for eligibility was to exclude foreigners from exercising presidential powers. Quote, "Permit me to hint whether it would not be wise and seasonable to provide a strong check to the admission of foreigners into the administration of our national government, and to declare explicitly that the command-in-chief of the American Army shall not be given to nor devolve on any but a natural-born citizen." Also on 25th July 1787, the very same day, ladies and gentlemen, James Madison made the following comment to the delegates of the Constitutional Convention in progress in Philadelphia. The topic of the debate was whether or not it would be a good idea to have Congress, state legislatures, the governors of the states or courts, federal or state, to choose the president. Mr. Madison: "Beside the general influence of the mode of the independence of the executive, one, the election of the chief magistrate would agitate and divide the legislature so much that the public interest would materially suffer by it. Public bodies are always apt to be thrown into contentions, but into more violent ones by such occasions than any others. The candidate would intrigue with the legislature, would derive his appointment from the predominant faction, and be apt to render his administration subservient to its reviews. 3. The ministers of foreign powers would have, and 7. Make use of the opportunity to mix their intrigues and influence with the election. Limited as the powers of the executive are, it would be an object of great moment with the great rival powers of Europe who have American possessions, to have at the head of our government a man attached to their respective politics and interests. No pains nor perhaps expense will be spared to gain from the legislature an appointment favorable to their wishes. Germany and Poland are witnesses of this danger. In the former, the election of the head of the empire, till it became in a manner hereditary, interested all Europe. and was influenced by foreign interference. In the latter, although the elective magistrate has very little real power. His election has at all times produced the most eager interference of foreign princes, and has in fact at length slid entirely into foreign hands. The existing authorities in the states are the legislative, the executive, and the judiciary. The appointment of the national executive by the first was objectionable in many points of view, some of which have been already mentioned. He would mention one of itself would decide his opinion. The legislatures of the states had betrayed a strong propensity to a variety of pernicious measures. One object of the national legislature was to control this propensity. One object of the national executive, so far as it would have a negative on the laws, was to control the national legislature, so far as it might be infected with a similar propensity. Refer the appointment of the national executive to the state legislatures, and thus controlling purpose may be defined. The legislatures can and will act with some kind of regular plan and will promote the appointment of a man who will not oppose himself to a favored object. Should a majority of the legislatures at the time of election have the same object or different objects of the same kind, the national executive will be rendered subservient to them. An appointment by the state executives was liable, among other objections, to the usurpable one that being standing bodies, they could and would be courted and intrigued with by the candidates, by their partisans, and by the ministers of foreign powers. The state judiciaries had not, and he presumed would not propose as a proper source of appointment. The option before us then lay between an appointment by electors chosen by the people and an immediate appointment by the people. He would the former mode free from any of the objections which had been urged against it, and greatly preferable to an appointment by the national legislature, as the electors would be chosen for the occasion, would meet at once and proceed immediately to an appointment. There would be very little opportunity for cavil or corruption. As a further precaution, it might be required that they should meet at some place distinct from the seat of government, and even that no person with a certain distance of the place at that time should be eligible. With one exception to be noted shortly, it was only after Jay's letter to General Washington and Madison's comment at the convention that the convention began to mention citizenship requirements for any constitutional officers, even though they had begun to consider eligibility issues about a week previously. It should be noted, however, that during the early days of the convention, several very different initial drafts of proposed constitution were presented, all but one of which were rejected. The last one to be presented by Alexander Hamilton is known as the British Plan because it was modeled closely after the British governmental architecture. Although that proposal was totally rejected, and they did reject it because they hated everything to do with England, it also happens to have been the only one whose text included any eligibility requirements for the chief executive. That plan required that the person be born a citizen. The convention's Committee of the Whole went into recess from July 27th through August 5th. When it resumed on August 6th, the Committee of Detail presented the first draft of the Constitution that included eligibility requirements for any constitutional officers. The members of the House and Senate had to be citizens for specified periods prior to serving, thus implicitly allowing naturalized citizens to serve, a point that was actually discussed in detail in the Committee of the Whole. But the only constraint on who could be president was that he shall not be elected a second time. And they, ladies and gentlemen, the founders of the country, were very wary of entrenched power. And notice here, during the proceedings and the constitutional debates, they only wanted the president to serve one term. And the Constitution originally had no term limits for president, because men of honor that served when our country was first founded knew that government wasn't a career, it wasn't a way to make money. They stepped down voluntarily because they were men of honor. Finally, on September 4th, the convention considered proposed changes from one of the subcommittees, where the natural-born citizen eligibility requirement for the president was introduced to the Committee of the Whole. The differences between the initial language and what later became the text of the ratified Constitution are minor and have no bearing on the meaning of natural-born citizen. Section 2. No person except a natural-born citizen or a citizen of the U.S. at the time of the adoption of this Constitution shall be eligible to the office of President, nor shall any person be elected to that office who shall be under the age of 35 years and who has not been in the whole at least 14 years a resident within the U.S. And excuse me. Based on the above evidence, we can conclude that John Jay's letter to Washington and the comments of Madison and later others at the convention established the fact that the framers were worried about the undivided loyalty of the president and thought that the requirement that he be a natural-born citizen would be sufficient to prevent anyone with foreign allegiance, anyone who could be claimed as a subject or citizen of a foreign sovereign, from serving as president. But how could that be if natural-born citizen means what many claim it does, namely a person born in the United States with parents who aren't employed in any official capacity by a foreign sovereign? Some nations claim you as their citizen or subject based upon where you were born, some based upon who your parents were, and some based on both together. By requiring that the president be born in a location where the U.S. is sovereign, any foreign natural law or law of nations claim on the president to allegiance based on his place of birth is precluded. By requiring that the president be born to parents who are solely U.S. citizens, and any foreign natural law or law of nations claim on the president to allegiance based on his parentage is precluded. There is no denying the fact that a person born in the United States could have multiple nationalities and owe allegiance to multiple sovereigns, since either parent could have multiple citizenships, any of which could be by the law of that nation transferred to the child by the principle of jus sanguinis. Many nations claim anyone who at least one parent, sometimes it must be the father, sometimes it must be the mother, sometimes both, who is a citizen or subject of that nation as a citizen subject also. However, if both your parents are citizens or subjects of the same sovereign, if neither parent has any foreign citizenship, and if you were born in the same sovereign territory, then and only then is it possible for any other sovereign to have a birthright claim to your allegiance under the law of nations as commonly understood. Therefore, it should be evident that in the purpose of the requirement to be a natural-born citizen is to prevent anyone with foreign citizenship from serving as president, and cannot achieve that end unless by definition the phrase natural-born citizen excludes anyone who might have acquired foreign citizenship by means of any one of the three modalities recognized by the law of nations. 1. Jus soli, born on foreign soil. 2. Jus sanguinis, born to a parent with foreign citizenship. Or 3. Naturalization by a foreign country. John Jay's request to Washington makes no sense otherwise, since in that case he suggested eligibility requirement would not preclude what he was seeking to prevent. It should be noted that a person can become a citizen or subject of a foreign country by naturalization after one has been born. To be logically consistent with the intent of the founders, those U.S. citizens, even if born in the U.S. to parents who are both U.S. citizens, who have any foreign citizenship, no matter when or how acquired, should not be eligible to be president. This issue has nothing to do with race or ethnicity. It is a question of loyalty and avoidance of even the appearance of conflict of interest. Nothing more and nothing less. Consider again Article 2, Section 1, Paragraph 5 of the United States Constitution. No person except a natural-born citizen or a citizen of the United States at the time of the adoption of this Constitution shall be eligible to the office of President, neither shall any person be eligible to that office who shall not have attained the age of 35 years and been 14 years a resident within the United States. That clause limits who may be president to persons who meet the following requirements: those who are 35 years and older, and those who have been a resident of the U.S. for 14 years or longer, and those who are natural-born citizens or those who were U.S. citizens at the time the Constitution was adopted. And that, ladies and gentlemen, means that if you were born after July 5th, 1789, you had to pass a stricter test, because the founding fathers obviously were not U.S. citizens at the time the Constitution was adopted, and they were not natural born because they were born in England. And if they didn't add that exception to the Constitution, there would have been nobody eligible to be president till the year 1822. Why did the Constitutional Convention include that last exception among those who were citizens at the time the Constitution was adopted to be president? Before answering that question, consider the case of Congressman Smith. He was born in South Carolina before the American Revolution. At the time of the Revolution, he was not yet an adult. His parents were British loyalists and fought against the Revolution. But after the Revolution and the adoption of the Constitution in 1788, he was elected to Congress. But his right to be seated was challenged on the basis that he was not a citizen due to the actions of his parents. James Madison himself spoke in defense of the fact that Mr. Smith was a citizen. The reasoning he had used is decisive with respect to understanding the reason for the exception in the Constitution to the natural-born citizen requirement. Madison essentially argued that Mr. Smith was a citizen because of where he was born, and because he was a minor when his parents sided with the British loyalists against the American revolutionaries. He focused on that point because he obviously felt that any adults who sided with the British loyalists would not qualify as citizens regardless of where they were born. He explains the reason for that. Bear in mind that the Constitution allows naturalized citizens to serve in Congress. There is no requirement that one have birthright citizenship, whose normative definition means either just solely or just sanguineous citizenship, but Madison nevertheless argued that Mr. Smith was a citizen from birth, by reason of his place of birth alone, and explicitly not due to his parentage, because as Madison argues, his parents never were U.S. citizens at all. Madison's argument prevailed, and Mr. Smith was seated as a congressman. The Congress accepted Madison's argument that Mr. Smith had birthright citizenship solely due to the location of his birth in South Carolina. Excuse me. When South Carolina was a British colony and not yet a state of the United States. By that same logic, most residents of the U.S. at the time the Constitution was adopted were native citizens of the U.S. by their place of birth alone. Note that according to Madison's argument, those who were citizens of any state became citizens of the U.S. instantly, automatically, and by operation of natural law and the law of nations, the moment two events occurred. One, the society in which they were citizens came under the sovereignty of the United States. And two, they were adults who accepted and did not reject allegiance to the United States. However, their status as U.S. citizens began only at that moment and not before. By Madison's rule, anyone born on soil where the United States is currently sovereign and who was not denounced or rejected U.S. citizenship is a citizen of the United States, although he didn't say what kind. However, most people who were alive when the Constitution was adopted would have had parents who were not U.S. citizens when they were born, because the United States did not exist until 1776 at the earliest. Whether the United States that came into existence in 1776 is the same nation as the one whose government was constituted in 1788 by the current U.S. Constitution is an interesting question, but there is no need to answer it here. The only persons who were indisputably born on soil in which the United States was sovereign when the current U.S. Constitution was adopted and whose parents were U.S. citizens at the very moment when those persons were born would, under the most lenient possible interpretation, have been no older than 12 years of age in 1788 when the Constitution was ratified. Under the strictest interpretation, they would have been mere infants. In contrast, most of those who were citizens when the Constitution was ratified would have satisfied the requirement to have been born on U.S. soil, because the soil on which they were born would have become U.S. soil no later than the moment the Constitution was ratified, if not before. So based upon Madison's argument, which Congress accepted, if natural-born citizen means simply native-born or born a citizen or born on soil where the United States is currently sovereign, then any citizen of the U.S. at the time the Constitution was adopted would satisfy the natural-born citizenship requirement. There would have been no need for the exception, and its inclusion in the Constitution makes no sense, especially in historical context, where no small number of residents of the U.S. were at least potentially British subjects per British law, and the undivided loyalty of many of them to the United States was under serious suspicion, as demonstrated by the case of Congressman Smith. But if natural-born citizen means born on U.S. soil, whose parents who were U.S. citizens when their child was born, then it would in fact be true that no one older than 12 years of age at most could have satisfied the natural-born citizen requirement in 1788 when the Constitution was ratified. In which case there is a good reason for the exception. Without that exception, and assuming a semantic for natural-born citizen as stated, George Washington would not have been eligible, nor would most of the presidents after him until well into the 19th century. In addition to the debates at the Constitutional Convention, John Jay's letters to General Washington, and the text of the Constitution itself, there is also the testimony of founder and historian David Ramsay, April 7, 1749 to May 8, 1815, who was an American physician, patriot, and historian from South Carolina, and delegate from the state to the Continental Congress in 1782 and 1783, and 1785 and 1786. He was the acting president of the United States in Congress assembled. He was one of the American Revolution's first major historians. A contemporary of Washington, Ramsay writes with the knowledge and insights one acquires only by being personally involved in the events of the founding period. In 1789, the year after the Constitution was ratified, Dr. Ramsay published an essay entitled A Dissertation on the Manners of Acquiring the Character and Privileges of a Citizen, a very important and influential essay on defining a natural-born citizen. In his 1789 article, Ramsay first explained who the original citizens were and then defined the natural-born citizens as the children born in the country to citizen parents. He said concerning the children born after the Declaration of Independence, citizenship is the inheritance of the children of those who have taken part in the late Revolution, but this is confined exclusively to the children of those who were themselves citizens. He added that citizenship by inheritance belongs to none but the children of those Americans who, having survived the Declaration of Independence, acquired adventitious character in their own right and transmitted it to their offspring. He continued that citizenship as a natural right belongs to none but those who have been born of citizens since the 4th of July, 1776. Based upon Dr. Ramsay's definition of natural-born citizen, there can be no doubt why it is necessary to include the time-limited constitutional exception that permitted those who were citizens when the Constitution was adopted to be president. Without that exception, those who would have qualified as natural-born citizens and so been constitutionally eligible to be president would have been no older than 12 years of age in 1788. Given Dr. Ramsay's position on influence, and especially given that he was a highly respected historian, Ramsay would have had the contacts with other influential founders and framers and would have known how they defined natural-born citizen. Being of the founding generation and being intimately involved in the events of the time, would have known how the founders and framers defined a natural-born citizen. And he told us that definition was one where the child was born in the country of citizen parents. In the country, ladies and gentlemen, of citizen parents. Not one parent, not born in Calgary, Canada, not born in India, not born on this soil with Cuban parents like Marco Rubio. The definition was one where the child was born in the country of citizen parents. Note Dr. Ramsay's phrase as a natural right. Modernly, it seems strange to us to associate questions of citizenship with natural rights. We consider questions of citizenship to be purely political matters, not questions of laws of nature such as those investigated by physicists. But that was not all true in the 18th century European culture, nor had been the case of English common law for many hundreds of years prior. At the time, science was still in its infancy, and in stunning and then very recent success inspired those who lived through the initial scientific revolution to seek natural laws to explain and justify their hypothesis, theories, concepts, and policies. and the tradition of English common law was grounded quite firmly in rendering decision based on what was true by nature as opposed to what was truly true by political decree. That attitude was especially strong among those who founded the United States and wrote its Constitution. They were determined to throw off the chains of tradition and arbitrary authority and to establish their society and government based on invariant, self-evident principles arrived at by the reason and conformance with objective reality. They used the term natural in a way similar to the way we modernly use the term scientific, in the sense of justified by reason and the way the world works, not by tradition of arbitrary human policy, which isn't quite the formally correct definition, but is nevertheless what most people mean when they use the term. That's why the political writings of the time constantly and incessantly referred to natural law. The point was to claim that the concepts, principles, rules, or laws under discussion were derived by reason and logic from objective facts, and not merely the remnants of irrational cultural traditions or political edicts. It was the age of reason, and naturalness was its standard of validity and truth. When the U.S. Constitution was written, the natural law that dealt with issues such as nationality and allegiance to a sovereign was called the law of nations. Modernly, we call this international law. In 1788, the preeminent codification, description, and an explanation of the law of nations was a work written by Emmerich de Vattel, entitled The Law of Nations, or Principles of the Law of Nature Applied to the Conduct and Affairs of Nations and Sovereigns. And the founders used the work by Emmerich de Vattel extensively when they framed the Constitution. The founders were not only familiar with de Vattel's treatise, they relied on it extensively when they wrote laws and constitutions of their respective states, not just the federal one. In section 212 of de Vattel's treatise, he states the following: of the citizens and natives, the citizens are the members of the civil society, bound to this society by certain duties, and subject to its authority, they equally participate in its advantages. The natives or natural-born citizens are those born in the country. Again, ladies and gentlemen, for the third time, natural-born citizens are those born in the country of parents who are citizens. Ted Cruz was born in Calgary, Canada. He does not fit the definition in the Constitution of a natural-born citizen. Neither does Marco Rubio, and neither does Bobby Jindal. So you can quit with phrases like, hey, dipshit Cruz is eligible, that I got on Facebook. Because you people who support Ted Cruz do not know what you are talking about when you debate me. You do not know the Constitution. You do not know how the Constitution was formed. You claim to be a patriot and claim to be for freedom, and yet you're willing to elect a guy who will, by his very taking the office, violate that very same Constitution that he is sworn to preserve, protect, and defend. And your argument that you support Cruz and the people's argument that they supported Obama is the same argument, you conservatives and you liberals out there. You're both the same, and you don't even realize that you're the same, because you quote-unquote like his message, that you're willing to support him. Well, you're supporting Barack Obama all over again, ladies and gentlemen. And I'm going to continue with this. This is a very long article, and I don't think that I'm going to get through it, because we are at the meat of the matter after this paragraph. The society is supposed to desire this in consequence of that what it owes to its own preservation, and it is presumed as matter of course that each citizen or entering into society reserve to his children the right of becoming members of it. The country of the fathers is therefore that of the children, and those become true citizens merely by their tacit consent. We shall soon see whether, or their coming of the years of discretion, they may renounce their right and what they owe to their society in which they were born. I say that in order to be of the country, it is necessary that a person be born of a father who is a citizen. Well, by that very definition, ladies and gentlemen, Ted Cruz isn't even a Canadian. He's a Cuban because his father was born in Cuba. If he is born there of a foreigner, it would be the only place of his birth and not his country. Note that Divatel defines natural-born citizen as the purest form of citizenship, requiring both just solely the law of the soil, citizenship, and just sanguineous, the law of the blood, citizenship, with both parents being citizens. Do you understand that, ladies and gentlemen? Do you understand that it means both parents being citizens? Do you understand that a natural-born citizen means being born on United States soil? I hope that you understand this, ladies and gentlemen. I really do, because Ted Cruz is not eligible to be president. Neither is Marco Rubio. And neither is Bobby Jindal. And that trash article written by the Harvard Law Review is a pack of lies, and that trash written in townhall.com is a pack of lies. And if you continue to support Ted Cruz or Marco Rubio or Bobby Jindal, that's your right. I'm not going to try to change your mind, but I will tell you that you are an idiot and you are a fool, and you're doing this country a disservice. You're doing the Constitution a disservice by supporting these people. And you're not a patriot, and you're not a good American. And that's going to conclude this broadcast for tonight. Good night, and peace be with you.